Okay, everyone, we're going to get started here. Thank you for joining us. Sorry about that. And apologies for the rescheduling for anybody. So thank you for making it and attending this July 11th event. Tonight's topic is Minors Counsel. Now what? I don't know too much about Stephanie or Ian, so I'm going to leave them to give introductions on themselves. Please take it away.
Thanks. Hi, I'm Stephanie Story. I'm a family law practitioner and minors counsel. This is my friend Ian Jones.
Hi, I'm also a family law practitioner and minors counsel here in the San Gabriel Valley. My office is in Pomona. And I am about now a 60-40 split, 60% minors counsel work, 40% private practice.
I do about 70-30, a lot of minors counsel, downtown, Pomona, Pasadena, stuff like that. So thank you all for coming. As he said, apologies for not doing this last month, but we got it together. So here we go. I hope you can all see the slides that we put together for you. What we kind of wanted to do was to go through the whole life of a case. What is a minors counsel? How are we even here? What do we do? How did we get here? And then what do you do? So the second slide. One moment. Okay. There you go. What qualifies a minors counsel? Oh, we lost everybody. There we go. We do special training. We don't just pop up. We do several hours of specialized training by different county organizations. The training is not just from lawyers, it's from therapists and evaluators, child custody evaluators. So our training does consist of a broad range of issues that pertain to being a minors counsel. If anyone's ever wondered how judges come up with the people they come up with, that's kind of where we start. We all we train, we do the yearly annual training, we keep up with the laws, we do our special annual upkeeping, and we inform the judges who we are, and so they're very well aware of what we do and what we're qualified to do.
As part of the training, we have to take, when we first qualify as a minors counsel, we have to take a more intensive training course. This usually consists of about 12 hours of specialized training that will be targeted specifically as to what minors counsel is tasked by the court to do. So as Stephanie said in the last slide, our training is not just by other lawyers or judges. A lot of our trainings are also conducted by organizations, therapists, clinical social workers, other people who are involved or who we would consider to be collaterals that we would contact when we're conducting our due diligence investigation, to take in the information for us to report back to the court. We also have experience requirements. If you've been practicing family law for probably about a year or so, you'll meet the experience requirement. So if you see under subsection F, you have to have been counsel representing a party or a child in at least 6 proceedings where child custody is the issue within the last 5 years. 2 of those proceedings must involve contested child custody visitations. And then you can also qualify under different types of proceedings. But I think we all know, if you've been in family law in any period of time, most of what is being contested, if a minor child is at play, is going to be custody and visitation. I can think just a handful of cases that I've ever had over my entire family law career where we had a child as part of a dissolution or paternity, but we didn't have contested custody issues. So in that regard, the experience requirements also come into play. When it comes to the appointment process, under the family code, there are several code sections that dictate our appointment. The most important is going to be 3050, 3051 of the family code. What's on the screen right now is actually the CRCs regarding minors counsel. But what's interesting, and I had actually never noticed this until I was talking to Stephanie getting ready for this presentation, but the CRC basically just republishes the family code almost in its entirety. So what you'll see here in the CRC is basically what the code sections say if you were to go back and compare them side by side. But in a family law case, anyone can request the appointment of minors counsel. It can be done sua sponte by the court itself, which is actually one of the more common ways minors counsel does get appointed, at least in my experience. But a party, an attorney for the party can make the request. That's probably the second most common way we do get onboarded onto cases. Sometimes it's just its own separate RFO, a request for order, that brings us there. I've never seen minors counsel be appointed on the recommendation of a evaluator or a family court services evaluator. It can happen, but I've never seen it. I think that's very much a far less common way that we do get appointed. But the court, once someone has made the request and they're going to consider what goes into it, should the request be granted, they're going to look at a lot of things. I think in my own personal experience, they're looking at what they would classify as high conflict cases. So cases where you might have two parents who can't cooperatively co-parent, at least at the time of appointment. There might be issues that require them to be communicating only via talking parents or our family wizard, monitored messaging systems that are very often ordered by the courts. Is there allegations of abuse? Are there situations where allegations maybe not rising to the abuse level, but let's say a common allegation that I see made is where someone doesn't have a bed. They might be co-sleeping with a parent, and one parent thinks that it's not age appropriate anymore. So there's a lot of different ways, and there's a lot of there's a lot of different allegations that can be made in family court that might give rise to why the court would consider the appointment. There are times where courts will also say, I might consider appointment of minors counsel down the road if you cannot make these changes now. And some of that does work for parties, but a lot of times I think we eventually do see a minors counsel get appointed.
And also, just to give a bigger picture, you can see there are 8 scenarios where a court should take into account when appointing minors counsel. And I think the biggest one is number 3. If the court thinks that we would be likely to provide the court with relevant information not otherwise readily available. The court really does have wide discretion to decide if one or multiple children need their own attorney. So I think that this rule is a really relevant indicator if you have a custody case, if there's any type of issue that the court can maybe have a question about, then he might appoint a minors counsel.
You know, and I think that's a good point that Stephanie brought up. If you look at number 8, it's not also uncommon to have more than one minors counsel on your case. So if you have more than one child, if the interests of the 2 children are going to diverge at a certain point, a minors counsel can be conflicted. They'll appoint a separate second minors counsel to represent the 2 children. That does get a little bit more complicated, but it's not an uncommon scenario.
And this is in here just to remind everybody that Family Code Section 3011A is really the umbrella that everybody works under. And it is pretty broad. We are all concerned with the health, safety, and welfare of the child. So this is, it gives the court wide discretion, and it gives us wide discretion because we are held to that same standard. We are here to determine really what we think is in the best interest of the children, and the court is looking to us to kind of fulfill this requirement that they also are obligated to fulfill.
And I think it's important too to point out that a lot of times the analysis on 3011 stops at health, safety, welfare. If you read the section, we also have to consider whether or not there is history of abuse in the case. That is a requirement. That's not something that is necessarily discretionary for the court. It's something that as minors counsel, we have to bring up as an officer of the court. We have to go through what the statutory analysis is. And it's one thing that I think does get left off more often than not. So how does the court issue orders? How do we know what to do is basically what this slide is about. And it can vary from judicial officer to judicial officer. We get orders sometimes that just say minors counsel is appointed pursuant to FC 3050, which is not helpful to us really at all. And then we have sometimes where we have minute orders that can be 3, 4, 5 pages long, where the court really goes through and delineates very specific things that the court has made findings on, maybe not formal findings, but will make findings on that do require the appointment. And so that again, that can just vary from JO to JO, but there are some important things that have to be included on the appointment order. One, the name, contact information of the minors counsel has to be included. That can't be left out. The other thing that has to be included, at least in Los Angeles County, is rate or amount of compensation for minors counsel. We'll talk about that a little bit later in the presentation in more detail. But we do have the PACE program in Los Angeles County that will cover minors counsel fees in costs. And then at the very end, the order that does appoint us is the FL 323, or the order appointing counsel for a child. And at the same time, we also have to file what's the declaration of counsel for a child, where we certify to the court that we are qualified to act as minors counsel.
How does the court choose a minors counsel? If any of you have been in court and seen how the courts do it, judges have a list, and the list is refreshed annually by all of the minors counsel in every county. And the judges have sometimes their own way of doing things. Some judges go by rotation. You'll see some judges perhaps appoint the same person for several cases. As we progress as minors counsel, some of us may develop some specialties, if you will, regarding certain issues. So one judge may want me to be there for instance, a violence case, and it may be sexual abuse. Ian's better at that. So we get appointed by the judges based on how they feel we are going to fit into a case. We have nothing to do with it. We get a call. Sometimes we get a call from the court clerk saying the judge wants to appoint you. Sometimes we just get minute orders in the mail that show we've been appointed. So we have no discretion as to what cases we get appointed on. We may be asked if we can take it, and we do have the option of not taking it, but we don't have the option once we are appointed if the court has already appointed us. We are counsel. So to the extent that any attorneys or parties think we may have some sort of bias or some sort of interest, we are on a list and we get appointed as the court sees fit.
I really think a lot of the times what happens is that judges have an idea about why they're appointing minors counsel. And at a certain point, they may take some things into account. You know, you may hear a JO say, do you think that for, let's say, a teenage girl who's going to be appointed counsel, Would that be better fit to have a female minors counsel or a male minors counsel? Those are relevant questions to be asking that are particularities, particularly to your case, depending upon what the issues are. Certainly, as an attorney, you can object to the appointment of particular minors counsel. The court may or may not ask for reason why, but there's a lot that goes into it. But again, as Stephanie said, just to reiterate, we don't know that we're appointed even sometimes. We find out we're appointed when you call our office or when your client calls our office, or we're on the attorney portal and we see the total number of our case count has gone up by 1. So in some instances, it's really that that we just don't know. This is probably one of the most important things that we could talk about during a presentation on minors counsel. And this is what are the rights of counsel? In a lot of ways, people like to remind us that minors counsel is just another attorney, just like anyone else on a case. They're absolutely right. The code, the rules, everything says that. But we are entitled to different types of information, and we would be derelict in our duties if we did not go through this list in trying to seek what that information is. Probably one of the most important ones here is that we have reasonable access to our clients. That means a lot of things. I've gone to schools to meet my client. I've made arrangements with school officials, principals, and I've had my client taken out of class. I don't like to do that particularly and personally, but in some instances, that is one way that I know that I can get access to my client without perhaps my client being coached by one parent or the other. We can seek affirmative relief on behalf of the client. We can file RFOs. We can ask for specific orders relating to our client. We are entitled to notice of proceedings of all phases of that proceeding. So even though minors counsel is appointed for child and custody visitation issues only, we are entitled to notification about everything. So for example, you have a dissolution and maybe the only major asset that you have in that community property estate is a community residence, and one party asks the court to make sale orders on it. We need to be notified of that. That is an issue that does impact under 3011 the best interest of our client. Is our client no longer going to reside in the family home that they resided in? Those are issues that we need to be made aware of. With the new attorney portals that the court has made, at least for LA County, it's easier for us to find out what's going on in our cases, but we still need to be notified. And if you do not notify minors counsel, the court may very well just continue your RFO.
And also, I'm not sure how many people have sat down and read this code. So we just wanted to show you just visually how many rights we have. 5.242I number 8 and number 11, I think are the most powerful rights that we as minors counsel have. We hold the client's privilege. We hold the child's privilege. We can assert them or we can waive them. And we can talk to pretty much anyone involved in this child's life. And that is really an important right that we need to have because the court is relying on us for information. We are advocates, we are attorneys, but our main role is as an investigator. We need information. So this code, this rule of court, I think is really important just so you can visually see all of the rights that we have. And then along with that is our responsibilities. Again, visually, it's a lot because we have a lot of rights, because we have a lot of responsibilities. Representing a child is unlike representing any type of other person. We are charged with representing their best interests, not only interviewing the child and reviewing records, making further investigations that we think are necessary. That gives us a wide berth, and that includes investigating the parents. Perhaps someone's got one too many DUIs, or criminal records that we stumble upon, or maybe some grandparents involved have a history we need to know about. So we have a broad range of responsibilities because we cannot rely on our clients, like adult clients, to give us information. And even if we can, you can understand how a child would relay information or not. We don't rely on our clients for that type of information. We rely on all the other collaterals and all the other records. So this code really gives us a wide range of what we can and well, we cannot. There's nothing we really can't do. We can even introduce witnesses, we can serve pleadings, we can have a lot of responsibilities that we do have to fulfill.
And I think one thing too that's important, I think every minors counsel that if you ask this question to will probably give you the same answer. One of the most important sources of information that we have is our client. But there are times that our client is a 4, 5, 6 month old child. That client isn't going to speak to us, or a 2-year-old. That client isn't in a position to competently tell us anything other than their favorite Bluey character, perhaps, right? And so as you look under the rule subsection 1, counsel's duties, unless under the circumstances, it is inappropriate. And so this gives us as minors counsel a lot of leeway. A lot of the times another attorney on the case may come in and say, well, you haven't spoken to your client yet, or you didn't talk to your client. I said, well, in this instance, given what the nature of the allegations are, my client is 4 years old. I'm not going to necessarily re-traumatize my client potentially, because I am not a trauma-informed therapist. I'm not qualified to do that. I'm not going to ask them specifically about potential domestic violence situations they may or may not have witnessed, but we do rely on therapists to do that. And so that's why we hold the privilege. We can call other collaterals. We can contact them. That's another way for us to get that information. So what other rights does minors counsel have? Again, there's a lot here. And if you look at the 323 form, it's all listed on that as well. I think it's another good visual representation to look at, but we interview, we observe the child. So in the previous slide, I said we may have a 2-year-old that we may not necessarily interview. That doesn't mean we don't want to meet our client though. I think every minors counsel I know has a section of their office that's devoted to plushie toys, coloring books, snacks, manipulatives, fidget spinners, anything that you can think of that would be of interest to a child to help them to open up, to contact you. I have that in my office. And then I let them take the coloring books home. I have little activity books with stickers and things like that. The older kids, I'll give them manipulatives or fidget spinners or something that's easy for them to play with while we talk. But in a lot of times it's just observing, can our 2 or our 3-year-old client, what can they do? What's their speech patterns like? Are they, I've seen clients that have come in and I've made recommendations after that, after I review their medical records, that I think maybe they need occupational therapy for gripping or for holding. Again, I'm not an expert in that, but I can observe it, and then I can then ask other people who are experts in the case. And then we go to court, and then I can request orders from the court to help make that go along. But we prepare for hearings, we prepare for trials, we advocate on behalf of the child, and we take positions relevant to legal issues. So that means that we'll make legal argument. We have the ability to file memorandums, appoints, and authorities. We may or may not do that from time to time. It's going to be a case-specific analysis that we make as to what we need to do, but we can introduce witnesses, we can cross-examine your witnesses, we can make evidentiary objections, we prepare motions, we file trial briefs, we can do all of that. So that's more along the lines of we're just another lawyer that's in the case, but we're another lawyer that's in the case that has more responsibility in some instances as to the minor child than just private counsel for parents.
And also, along the lines of what Ian said, if you look at 5.242K3B, we have the right to seek and advocate for services for our child. And D, we have the right to work to settle contested issues. So we're not backseat drivers on one specific tiny issue. We can also take a bigger role in the entire case. And we can ask and advocate for services for our client if we think they need therapy, if we think they need other services outside of our initial appointment. But if you notice, it does say we are not required to assume the responsibilities of a social worker, probation officer, child custody evaluator, or mediator. We're not expected to provide non-legal services to the child, but in our investigation, we do have the right to explore all issues regarding that child, our client, and what they may or may not need and may or may not be getting from these parents. That could come as a surprise to some people involved in a case where they think perhaps it's a simple custody case, and minors counsel finds out there are a lot of other issues here that may need to be addressed.
See, we've done that one too. So we come to Family Code section 3151. This is one of the minor counsel code sections that I had referenced earlier. We put it up here pretty much just for your informational purposes. But the important takeaway from this is that the role of minors counsel is to gather evidence that bears on the best interests of our clients. We present admissible evidence to court. And then I think this is the one that's important. There's interplay between this and another code section we'll talk about in a little bit. But if the child desires, it's our duty, it's our ethical obligation to present the child's wishes to the court. And so that's here, we'll go to the, oh, I think I went backwards.
Yeah, that was the next.
Let's see, I have messed this one. Here we go. It's important for us to also know what our ethical obligations are to our client. Just because our client is a minor doesn't mean that we're still not obligated to follow through on those ethical obligations. That doesn't mean, though, that we, as the attorney, will always join in our client's wishes. We present them to the court can give them the due weight that the court so thinks that it's deserving of. There are times where you may hear minors counsel say something along the lines of, this is what my child, my minor client's wish is, but we don't necessarily join.
And this is the rest of 3151, which is our rights, which were mentioned in the California Rules of Court. This is the code section most judges will cite in our orders. It's actually in our orders. And I think the most important one for us is 3151C5. We have access to their medical, dental, mental health, healthcare records, education. We have the right to interview anyone, as you can see, school personnel, healthcare providers, healthcare professionals, and others who have accessed the child or provided care to the child. That is a broad stroke. The court is relying on us to talk to anyone who has information about this child. So that gives us a lot of rights here. And we do run into resistance from counsels every once in a while and parents don't want us going through DCFS records, don't want us going to talking to babysitters, but we have the right to do that. So understand that minors counsel is not here to throw a wrench in your case, to cause problems, to make things difficult, but we have an obligation here under this law. This is what we are supposed to do. So if I need to talk to your client and her mother and her sister and her other brother, then that's what I'm gonna do. If you don't want me to, I have to take action to get that information. So it's really, this whole presentation is just to kind of an overview of all of our duties here. And the more cooperative everyone can be with us, the better I think it is for the kids in the big picture.
Absolutely. And so here we have 3190. We get told that we're basically the purveyors of therapy for minor clients a lot. And I think it's true. I think we do recommend, or we request, that clients go to some sort of therapy fairly often. A lot of the times we've also been told by counsel, courts can't order it. It's not exactly true. I refer them to Family Code 3190, that the court may require parents or any other party involved in a custody or visitation dispute and the minor child to participate in outpatient counseling with a licensed mental health professional. This is an important part of repairing relationships, if that is something that needs to be done during the court case that we go on. In some instances, parents need to have a little bit of insight into their own actions as to why they may find themselves in a particular situation. This is the code section that the courts rely on to do that. So I'll leave that there. And again, everything too also is always going back to what's in the best interest. So the court will necessarily make finding that therapy is in the best interest. Family Code Section 3190 goes on. You'll find that, the court in its findings shall set forth the reasons that I had said earlier. But it also deals with financial costs. We all know that mental health therapists, counseling is not cheap. It's becoming more and more common that, health plans are covering it. But that's not always dealing with everything. We are cognizant as minors counsel that some of our parents do not have the financial means to work with this. If you represent a parent like that, talk to your minors counsel. We have a lot of contacts with community organizations that your client may qualify for, where they can receive that counseling. It's okay. Some parents are, I think, a little bit embarrassed at times to say that they're having issues with that. But it's something that if we really think it needs to be done, we'll work with you to do it. I feel like a broken record on this one. This is the way that we get some of our best information from our clients, is through the professional services of a mental health therapist.
And a lot of times we will get pushback that we can't afford it, our clients can't afford it. And depending on the situation and on the facts, I will insist on a therapist. So to Ian's point, you can work with us, we will work with you, but at the end of the day, if our clients need a therapist, we will push for that therapist. So this code section does give the court guidance as to how to fix the cost of the therapy. If parties have insurance, perhaps we can try going there, but this code gives us the right to ask for a therapist, and it gives the court direction on who pays for it.
And then we go to Family Code Section 3152. We find in a lot of our cases when we're being appointed that there may have been previous dependency court involvement with this family, or at least DCFS involvement with this family. We, as counsel for the child, we're allowed access to those confidential records under the Welfare and Institutions Code. But to be very honest, there are times where we can make requests for those records. They may not be returned to us in a timely manner. Those requests are handled by county counsel's office and the dependency court. We have no control over that. We'll make our requests as soon as we know that involvement has been made. But we don't always get everything that we do need. Or we don't get them on the time frame that we would particularly like to have them, so that we can return to the next court hearing and make a full, proper report to the court. But also just be aware that, you know, we can file motions, RFOs, to get these records if we have to. If for some reason the county counsel's office denies the request, whatever happens with that, 3152 outlines the procedures that we go through to get those reports. And then again, just because we can get that information, it's still confidential. We can't file that with the court, just like the parties can't either. So it's information that we can learn. It's information that can lead us in other directions so that we can have a more thorough, robust investigation. But we're not going to be introducing DCFS social worker records, reports, or anything like that. If that's something that we need to do, then we're going to have to be subpoenaing the social worker.
And judges can also order us to get DCFS records regarding our clients' siblings. So it's not, if it's relevant in this code section, it's pretty broad. Any relevant reports concerning our representation, we may have to get records from other siblings and other children. And I know that some attorneys and some parents, they do not like that, but we have the right under this code to do that. And this is just a typical appointment. I don't know if everyone has seen it. This is what we get from the court. And the next 2 pages, you'll see our rights and obligations are right there. We have the following rights. It is right there. So everyone knows our duties and our responsibilities and our rights. And then this is just what we file.
This is our declaration of counsel. So this is just saying that we're still qualified. We've kept up to date on our CLEs.
So Family Code Section 3042 is what we run into a lot with the older clients. So this code section does say that if a child is of sufficient age and capacity to reason so as to form an intelligent preference as to custody or visitation, the court shall consider and give due weight to the wishes of the child. Now, we understand that we represent our child, and usually when you represent a client, you convey their wishes to the court. But our role is much more nuanced than that. So our client may be 14 years old, and he or she may have strong feelings about custody visitation, and we may express their wishes to the court, but that's not the end all be all. I tell my clients and I tell attorneys that we don't give the keys of the bus to the kids. We don't let the kids drive the bus. We are all still obligated to do what's in their best interest. And sometimes what they want is not in their best interest. You know, the fun dad, the disciplined mom, they may have reasons why they're telling us things they're telling us, which is why we do the training that we do, which is why we have access to collaterals and records to really figure out what is really in their best interest. So we do listen to our clients. We do understand this code, and we will express what they wish, but that's not necessarily the end of the discussion.
And I think one thing too that counsel will bring up a lot of the times, if you look at subsection C, if the child is 14 years or older and the desire or the wish to address the court is strong, the code allows and says the child will be permitted to do so unless the court determines that in doing so, it's not in the best interest of the minor child. It's a lot of discretion that the trial court has in making that determination. If the court does determine that it is in their best interest to do so, I think we need to go back to section B and we look at 765 of the evidence code, where we control what that examination will look like. I know I've personally had quite a bit of argument with judicial officers in some cases about what does that look like? Are we in a closed courtroom? Are we doing questioning by the attorneys individually, or are we submitting questions to the judge or the judge questions? There's a lot of ways that you can tailor that depending upon the specifics of your case. But always remember that at the end of the day, it is the judge's decision as to whether or not the minor child will be able to testify under this code section.
And with that, remember, we still hold the privilege. So if attorneys or their parents want their kids to testify, they're gonna have to deal with our privilege of whether or not we waive it. So it can be a really, really challenging area when you've got older kids who want to testify, or parents want their kids to testify because they think they know what their kid's gonna say. And let me tell you, you may think you know what your kids are gonna say. I don't think you do. We as Minors Counsel learn so much about these kids that the parents really may or may not know. So wanting them to testify may backfire, number one. Number two, I don't think I have never agreed to that in really any circumstances. So most Minors Counsel will not be happy with an attorney or a parent who wants the kid to testify. The court can give us options such as submitting questions that the judge can ask, for example. So there are ways for the child to be heard, as this code section says, but our rights and our holding of the privilege carries a lot of weight.
And this is also the time where you might see a judicial interview of the minor child. Those are typically done in chambers with Minors Counsel present and the court reporter present. And then the judge can come out and address the rest of the parties and give a little bit of an update about, you know, what was there, and again, you can make argument, but also just be aware that in a lot of times with judicial interviews, that part of the transcript is also sealed. So,
and as our job as Minors Counsel, we may take into account for instance, if one parent is pushing for their kids to testify and it's really not appropriate, that goes into our overall analysis and report to the court. So it's really an important issue, and to really reconsider if you wanted kids to drag them into court to testify when there's other ways to get evidence.
So this is an interesting question that actually came up on the Los Angeles County Family Law Section listserv just earlier this week. And we wanted to talk about it. I think both Stephanie and I found it to be really interesting. But what age do minors have to be to have a minors counsel appointed? And as I said earlier in the presentation, I said we're going to come back and talk about this, but there really is no age limit for appointment. The youngest child I ever had appointed was 2 months. Minors counsel can be appointed for a child still in utero. That's allowed by the statute. And so it's really not that, is there an age limit? It's how is minors counsel going to make the representation? It's all done based off of best interest. And so, like we said earlier, communicating with clients may or may not be necessarily appropriate. In most of the cases, it's going to be appropriate, and it's going to be something that we do, and it's going to be something that we may do multiple times. But like we also said, it might just be observing a child. It might be observing how a child interacts with dad, and then observing how the child interacts with mom. Or we have an older child who's disabled, who might have an intellectual disability. Or we have a child who is medically fragile. And there's just a lot of different considerations that have to go into making those decisions as to how it is best for us to represent our client. Just like how a counsels for parents, you get to make those strategy decisions as to how best do you present your case. We do the same. We do the same thing. I don't know. So do you have anything else to add onto that one?
Yeah, just, to add on to what Ian said, observing our young clients really tells us a lot. I had a case years ago with a 2-year-old who was nonverbal, and when I watched him, he couldn't hold scissors and he couldn't hold a pencil. So I was able to advocate for speech therapy and occupational therapy and all these things that the parents missed for one reason or another. And I'm not judging the parents and I'm not blaming them, but I was able to, I guess, as an outsider of the family, if you will, see all these things. So just because we can't communicate with our clients, it does not diminish our effectiveness. And in some cases, it actually helps us to do what we really need to do for them. And we just included evidence code 765. We referenced it earlier as to the form and manner of how you're going to have a child witness. This is even under the age of 14. The court shall take special care to ensure that questions are stated in a form that are appropriate to their age and cognitive level. And the court can, in the interest of justice, forbid certain questions in certain forms. Just as a general rule, I avoid bringing kids into court pretty much at all costs. There are other ways that all counsel can work together to get the information that's needed here. And again, if someone insists on dragging my client into court, I'm going to have an issue with that.
So after minors counsel has been appointed, what happens next? We generally have 10 days to file our declaration with the court. And understand that it may take 4 or 5 days for us to get notification from the court that we've even been appointed. It may even take that long for us to get access to the attorney portal. It just all depends upon how quickly that minute order is processed internally by the clerk's office. But once we find out we're appointed, you've contacted our office, we generally will send out these things to the parties or to counsel first. A letter explaining who we are and basically also outlining how we're going to handle the case, at least at the very beginning. We always send release forms for records and information. That may sound counterproductive after we just went through, this is what the rights are, this is what the codes and this give us rights to access. From a purely practical perspective, it is sometimes easier just to have releases signed by both parents to get that information without necessarily having to have a more detailed discussion with a doctor's office, a dentist's office, or the school. We always send out forms and questionnaires about the parents, and then we send out forms and questionnaires about the minor child, asking the parents to complete that. And then, of course, more relevant to this presentation, but if you're representing a client, we're going to need a waiver signed by you, the attorney, for us to speak to your client outside of your presence for the purposes of custody and visitation issues only. But we ask that you also at that point explain to them that anything that they tell us is not confidential, not privileged. We're not their counsel. And at the end of the day, anything that they say to us, we may use ultimately in a report that we make to the court.
And also the 10 days is kind of important because a lot of times you're in court, your client's in court, and then we get appointed and your clients call us right away. We have no idea what's going on. We have no idea what case this is, and we cannot start working until we file our declaration. And if your clients are represented, we can't talk to them yet. So it's just really important to just give us a few days to get acclimated to your case.
And so these are, again, things that minors counsels can do. We can speak with both parties with the permission of their counsel more than one time if we need to, in a manner that works best for the parties. So especially during COVID, we had to go remote. Everything was on Zoom. I think most minors counsel, I feel fairly confident saying this, we prefer to meet our clients in person. You get a better observation from that. And I think we prefer to meet parents in person But we're also cognizant, people work, people have schedules, it's hard. And so a lot of people will do it in different modes now. Like I said before, we speak with the minors anytime, anywhere, in a way that again is appropriate. We speak with collaterals, teachers, therapists, counselors, school counselors, neighbors. I've gone next door to talk to a neighbor after I've conducted a home visit. We can conduct home visits. There might be a little bit more of a split between minors councils in this particular area. Do we conduct surprise home visits or do we give notice? I personally tend to fall more in the noticed home visit camp than I do in the not noticed home visit camp. But again, it depends on what the specific orders your JO has given. Sometimes the judges order us to photograph conditions in the home if there are concerns. And we lodge those photographs with the court. They go under seal in most cases. But you know, we do what we're ordered to do, again, by the court. We obtain records, like we've said earlier, and then we may visit, you know, the homes. We may visit one home, we may visit both homes. We may also want to visit the babysitter. We may want to go to their school, if there's an issue regarding that. So as much variety as there is in cases, there's as much variety in the types of things that we need to do or that we may be called on to do by the courts.
And I fall in the camp of I always give notice. The previous slide which said we are not expected to be social workers. We are not. We are very clear about we're not visiting homes looking for things. If there's an allegation that we think is appropriate, then we would like to go see what's going on and just see how they live and where they live. If the issue is where are they supposed to live. We also might have an army of collaterals in a case that we have. For instance, I've had a case with 12 different people I had to talk to. My job is to report to the court. Anytime you get a case with minors counsel, the judge will generally refer to minors counsel at the hearing first, and they'll ask us, give your report. So I'm going to tell the court everyone I spoke to and what they said. And it may seem like hearsay, and perhaps that is an issue that overlaps, but that's also our offer of proof, right? So all of the information we're getting from these collaterals, it is evidence. It is our offer of proof as to what we investigated. And it's up to the court to determine the weight of everything we're telling them.
And it may not happen every time, but I've had judicial officers order me to subpoena witnesses and bring them into court, hail them before the judge, was the specific phrase that this JO used. And we do, if that's what is necessary to do. Again, we have that power. We're just like other lawyers in the case. I think we prefer not to have to take that route, but we will if we have to.
So this is kind of the slide that gave us the idea for this presentation, is how to work effectively with minors counsel. We didn't want to start with that because we wanted everyone to understand how we get here into your case and where we come from and why we would be here. So this is basically how Ian and I, and we took an unofficial poll. I have no scientific evidence, but I talked to all my friends who are minors counsel. And this is kind of the consensus of how to work effectively with us, because the court has appointed us to your case for a reason. We are here and we have a job to do. So as I said earlier, give us a reasonable amount of time to become familiar with your case. It really helps if attorneys give us permission to speak to your clients, because if we cannot speak to one of the parties, it does not stop our investigation. It just doesn't give us that person's perspective. I personally want to hear from both parents. I want to hear their sides. If one parent doesn't want to talk to me, then I'm not going to have that parent's side, but it's not going to stop me from giving a report and forming an opinion that may or may not be completely accurate. So really, if I understand, and Ian has said that our conversations with your clients are not privileged, but we really do need to speak to the parents of our clients. We also need them to fill out the forms and releases in a reasonable time. We need them to respond to us when we have questions. We need them to communicate and update us. If my client had a breakdown at school, I need to know that. If I'm learning that 2 months later, it really hinders everyone. So we really need information. We also need to have reasonable and frequent access to our clients, especially the younger, some are younger kids who don't have their own phones. I need to talk to my client and he needs or she needs to talk to me. So the more cooperative the parents can be to us, the more effective we can be. And this is the big point that we really want you all to understand. And I hope you believe that we are not opposing counsel. We are advocates. We're not neutrals, but we're not opposing anyone. We're here for a specific reason. Our opinions may feel like they're opposing you. We may have differences, we may not agree, and that's okay, but we still wish and hope that everyone still continues to work with us, even if we don't agree on our opinions.
And just because we may align, or it seems like we're aligning with mom's counsel on this RFO, doesn't mean on the next RFO, we don't align with dad's counsel. And so it's all having to do with where we are for best interest. And so this is, what does minors counsel need to know about your case? Everything. We need to know everything. And that's sometimes the problem. Parents will think, well, minors counsel is very invasive. We are. We understand that. We try to limit the invasiveness as much as we can, but we need to know, is there history of domestic violence? Maybe it is outside of the 5-year time period, but we need to know. Are there mental health issues? We need to know. Are there cognitive or developmental issues with our clients? We need to know. So if there is a question as to whether or not should we disclose something to minors counsel or not, I always say, think back to like your favorite class in law school, property. Do you disclose that the back room is haunted by the ghost? Yeah, you probably should. Let us know. It's easier to disclose to us. Let us make that determination if it's relevant. And in a lot of times, maybe it isn't. But if you don't, and we find something out later, and it's something that's serious, now you're having to deal with the particular issue, but now you have the added on issue that we had to find out some other way. It's always better to tell on yourself. How do we get compensated? People always ask us this, how do we get paid? Sometimes it's a private pay case where the parties are responsible for paying us. Other times it's done through PACE, but the code does allow us, we are entitled to reasonable compensation that has to be set at the time of the appointment. And so there's this great question of one party says, I can't afford to pay minors counsel. Okay, that's fine. That may very well be the case. File a fee waiver. Have your client file a fee waiver and keep an updated FL-150 on file. That is one way to ensure that you can keep your case under PACE, or you can get a PACE appointment if you didn't have one before. And if you're doing it, just helpful practice tip, file the fee waiver 002 form, mark minors counsel fees.
This code, this rule of court 5.240 says the court must determine their ability to pay. And the court will make the determination that it will. We do not advocate for our pay. We have nothing to do with how we're going to pay. We're going to get paid, who's going to pay us, or how much we're going to get paid. That is entirely up to the court. And I, for one, don't argue or don't have any preference for how we get compensated. So the arguments about pay, that has to come from the attorneys, and we abide by whatever the court rules.
So again, that's just the last parts of the CRC. This is the last of the minor counsel codes, 3153. And it deals with compensation. So you'll see PACE orders that might come through and they'll say subject to reallocation. I think actually all of PACE orders are subject to reallocation. And if you're like me, when I first started practicing, I didn't know what PACE was. It's the Professional Appointee Court Expenditure Program. It is a specific program that's tied to LA County. There's some other counties throughout the state that also have PACE. Part of it is funded through the county and through a state grant. But the court sets our hourly rates. Any appointments prior to July 1st of this year, our hourly rate was $150. We did get a raise So anything new appointments, we now get 165. And you'll not necessarily see our PACE billing, but the court does. The judicial officer signs off on every billing invoice that we submit to PACE. They have to see it, they approve it.
These are the PACE levels that we can be appointed. I am not 100% sure about the amounts of levels 2 through 6. The last standing order I could find was from 2019 from Judge Lewis. But I do know that level 1 was bumped up from 3,000 to 3,500. So I think these are right amounts, but if anyone knows different, please let me know. But the descriptions of the levels are accurate. So we can be appointed levels 1 through 6, depending on how many kids, how many issues, what's going on. We can also ask to be bumped up. So if I am on level 1 at the initial appointment and a year later, there are several issues, I can ask the court to make me a level 3 or level 4. It's going to depend on a lot of factors regarding the case. Some judges do it subject to reallocation and will ask the parties to reimburse the county. And that's going to depend on the court's analysis of the party's ability to pay. But for the time being, we will be compensated by the county based on whatever level we are at.
Okay. How to terminate a minors counsel. This is also something that lawyers really like to know about. You can ask the court and you can say, this is the issue that we have. I think every minors counsel at some point has asked to be relieved by a party, or counsel doesn't do it that often, but parties certainly will. And if that's the case, the court may set it for evidentiary hearing, or they may just hear arguments on it, right then and there. But I will caution that again, this is not official, this is not a formal survey. It's not something that courts do very lightly, and it's not something that courts do very often. So if that's something that you need to do, I think you need to just make sure that you go in and you have, lots of something to back up what your request is.
Right. It is, the standard is for good cause. If you do believe for some reason that minors counsel should be removed from the case, I don't anticipate you would get an opposition from minors counsel. Remember, we were appointed, the court determined we should be here. If the court determines we should be removed, then that's going to be the ruling from the court. I, as minors counsel, would, depending on the circumstances, just relate to the court what I've done and that sort of thing. But if you want a minors counsel removed, you are going to have to come in with good cause, and it will just be up to the court.
A lot of times minors counsel will just ask for themselves to be relieved if they can no longer continue on as minors counsel. They're changing employment. That's how that goes as well.
So just closing remarks, just remember the court appoints minors counsel for a reason. And we're not opposing counsel, despite how it may feel at the time. And not cooperating with us will not prohibit us from proceeding. It'll just kind of hinder us. And you really should trust that we do have the best interests of our clients at heart. And the orders that we request will be based on their best interests.
All parties don't necessarily have to agree with what we're doing, and certainly most times they don't. But all parties are free to make their positions known to the court, just as we'll make our position known to the court. I think the big thing too to remember is that we don't make recommendations to the court. We're not neutrals. We make requests on behalf of our clients, just as private counsel will make a request on behalf of their client for orders from the court. You may still hear some judges ask us for our recommendation. I think most of us very politely just fill in the word request when we respond, but that's a change. We have some people are just used to saying the other way. But we're not making recommendations. We're not taking on the position of some sort of quasi-judicial function. We can't make orders. We can't do that. That's all left up to the judicial officer to do. We are an advocate, but we also make and provide information. We provide information to the court. We don't make it, but we provide it. And that is one of the essential functions that minors counsel has. And then again, ultimately, the decision maker at the end of the day is the judge. They're going to have to make findings that are consistent with the facts and the law. And they are also going to conduct a best interest analysis. They're going to look under everything that's going on. We're here to provide information. It's up to the court and for all of us to synthesize that information and then ultimately come out with what is the best interest for our client or our minor clients. So I want to thank you for taking a time out of your evening today. We obviously think this is a very interesting subject. I think we all find it to be very rewarding. I know I do. It is a tough job, but it's a job that at the end of the day, I do feel that I am making an impact. And I love it, and I don't know that I would ever change it. But again, thank you so much, and I appreciate your time.
And we also hope that this inspires other attorneys who want to become minors counsel. Please sign up, take the courses. It's really worth it.
There's plenty of work to go around, trust me. Does anyone have any questions?
There's nothing in the chat, so.
If you have questions, just hop on.
Sherry Davidson says, thank you.
Oh, thank you, Sherry.
Oh, thanks, Sherry. Okay, well, thank you guys. You can also always email us if you have any questions, and thank you so much for coming. Thank you.
Thanks.
Everyone keep an eye out in your emails. You will be getting your evaluation forms and your MCLA certificate. You just need to sign up for your record of attendance. So just keep an eye out. You should have already gotten the email.
Okay, thank you.
Thank you, everyone.
Thank
Have a good
you.
night.